What is probate real estate, and how do you sell it? To sell probate real estate, the executor or administrator first needs court authority, then they confirm whether the sale needs court approval, protect the property, resolve title, creditor, and tax issues, market the property, and close under state probate rules. Probate real estate is property that is part of a deceased person's estate and cannot be sold or transferred cleanly until probate authority or another valid transfer path is confirmed. That usually includes a home, rental property, land, or commercial building titled only in the deceased person's name or titled as tenants in common. It may not include property already passing through a living trust, a transfer on death deed, a survivorship deed, tenancy by the entirety, or another non-probate setup that works in that state. I'm Rhett Fruitman, co-founder of Inherited Property Match. My background includes City Private Bank, CBRE, and helping families navigate inherited property sales across the country. This is general information, not tax, legal, financial, or real estate advice. Before you sell inherited property, speak with a CPA, and when probate or trust administration is involved, an estate or probate attorney. The main point is simple. Probate is not just paperwork. It is the process that gives the right person the legal authority to deal with estate property and protect the beneficiaries before a sale closes. When can an executor sell probate real estate? An executor or administrator can sell probate real estate after the probate court appoints them and issues authority, usually letters testamentary for an executor or letters of administration for an administrator. Those letters are the document buyers, title companies, brokers, and banks look for because they show who has authority to act for the estate. Can an executor sell a house before probate is complete? In many cases, yes, but only after appointment, and only if the will, court order, and state probate process allow the sale before final distribution. Before appointment, an heir may have an expected inheritance, but that is not the same as clean authority to sign a listing agreement, accept an offer, transfer title, or bind the estate to a sale. This is why the first practical question is not, what is the house worth? The first question is, who has authority to act and what document proves it? Does the probate court have to approve the sale? Probate court approval is required when the estate is supervised or court confirmed, but an independent administration can often sell without a separate approval hearing if the will and state law allow it. In an independent administration, the personal representative may be able to list the property, negotiate with buyers, accept an offer, and close with fewer court steps while still following notice, fiduciary, and accounting duties. In a supervised or court-confirmed sale, the court may need to review the sale terms before closing. That can add notices, hearings, waiting periods, and in some states, possible overbid procedures. Is a probate sale the same as a regular home sale? No. A probate sale can look like a normal listing, but the authority, disclosures, deadlines, buyer expectations, and possible court approval make it different from a standard owner-occupied sale. This difference matters because the wrong buyer strategy can waste months. A buyer who needs a fast, normal closing may not be the right fit for a sale that still needs court confirmation. How long does probate take for real estate? A simple probate real estate sale may close within a few months after the personal representative has authority, but court-supervised sales, creditor claims, title defects, disputes, or local court delays can push the process to a year or more. The sale timeline is not just marketing time. It can include the petition for appointment, issuance of letters, appraisals, insurance review, property cleanup, title work, creditor notice periods, beneficiary communication, buyer financing, and sometimes court approval. Why does probate take so long? It often slows down because the estate has to protect creditors, beneficiaries, and clear title before money can safely move out of the estate. The house may sell quickly, but final distribution can still wait until claims, expenses, taxes, and the estate accounting are handled. A realistic timeline protects the family from false expectations. The goal is not just to get a buyer. The goal is to close a sale that the court, title company, beneficiaries, and tax professionals can all live with. What does the executor have to do before listing the property? Before listing probate real estate, the personal representative should secure the property, keep insurance active, confirm title, order a date of death valuation, preserve records, and coordinate with a probate attorney, CPA, and probate experienced broker. The personal representative is acting in a fiduciary role. That means the job is to protect the estate and all beneficiaries, not to make the fastest or easiest decision for one person in the family. The practical checklist usually includes changing locks if appropriate, checking for vacant property insurance issues, keeping utilities safe, preventing damage, documenting personal property, reviewing mortgage or reverse mortgage deadlines, and tracking every estate expense. Can heirs empty or renovate the house before probate? They should not remove valuables, make major changes, or spend estate money without authority, documentation, and a plan that protects all beneficiaries. Small cleanup can help a sale, but undocumented removal of belongings, rushed repairs, or one heir making decisions alone can create conflict, accounting problems, or title delays later. What problems and tax issues can delay a probate sale? The most common probate sale problems are title defects, heir disputes, occupied property, deferred maintenance, insurance gaps, reverse mortgage deadlines, property tax reassessment, and confusion over who reports the sale. Inherited homes usually create emotional issues around belongings, condition, and family disagreement. Rental properties add tenants, rent collection, leases, deposits, repairs, and income tracking. Commercial properties add lease analysis, property management, environmental due diligence, valuation complexity, and a narrower buyer pool. What happens if inherited property has tenants? The estate generally has to honor leases, collect and account for rent, handle deposits correctly, maintain the property, and disclose the tenant situation to buyers. On federal income taxes, probate does not erase the core inherited property rule. Inherited property generally receives a stepped-up basis to fair market value at death, so capital gain is usually measured from that date of death value, not the original purchase price. Do heirs pay capital gains tax when probate property is sold? Capital gains tax is generally based on the difference between the sale price and the property's adjusted date of death basis, but a CPA should model whether the estate reports the sale or the heirs report it after distribution. If the estate sells during probate, the reporting may involve the estate's fiduciary income tax return and Schedule D for Form 1041. If the heirs receive the property first and then sell, the reporting may move to the heirs. That reporting choice is a tax question, not a guesswork question. Can probate be avoided or simplified? Some inherited property avoids probate if title already transfers through a living trust, survivorship deed, transfer on death deed, tenancy by the entirety, or another valid non-probate setup. The deed usually tells the story. If the property was titled in a trust, the successor trustee may be the person with authority. If it was held with a valid survivorship structure, the surviving owner may be able to transfer or sell without opening a full probate case for that asset. Some states also allow small estate affidavits, summary administration, or simplified transfer procedures, but the thresholds and real estate rules vary by state and by date of death. What is ancillary probate? Ancillary probate is a second probate case that may be needed when the deceased owned real estate in a different state from the main probate case. So if someone died in one state but owned a vacation home, rental, or land in another state, the family may need to solve both the main probate and the out-of-state title issue before selling. What should heirs and executors do next? Heirs and executors should not list probate real estate until they confirm legal authority, tax reporting, title status, property condition, and the right probate experienced broker. The best next step is to build the team in the right order: probate attorney for authority and court process, CPA for tax reporting, and a real estate broker who understands estate-related sales. If you inherited property and need help finding a broker who understands probate and inherited property sales, Inherited Property Match can connect you with a vetted broker experienced with estate-related real estate. The match is free. You do not have to figure this out alone. The process is manageable when the legal authority, tax reporting, title work, and sales strategy line up.